The training objectives of this presentation are to provide you with a refresher on the Public Health Department Compliance Program. This includes reporting tools and clarification on how, what, and when to report, a refresher on fraud, waste, and abuse elements, and review of recent compliance incidents. Note, this training is for the compliance program only. Privacy and cybersecurity are separate trainings. As this slide depicts, there is a lot of government oversight and scrutiny on healthcare operations. Why is this? There are many reasons for this oversight, such as quality of medical care, access to healthcare coverage, and purity of pharmaceuticals. However, one of the main reasons there is so much focus is a history of abuses, such as Medicare and Medicaid fraud, poor patient care, and discrimination. The Public Health Department monitors information from many of these agencies on a monthly basis to ensure that our staff and vendors are approved to provide healthcare services and have no current or past actions that may prevent them from doing so. There is a glossary for all of these acronyms at the end of this presentation, but some of the common ones and their relationship are CMS, Centers for Medicare Medicaid Services. Medicaid is Medi-Cal in California. OCR, Office of Civil Rights, which is responsible for ensuring HIPAA compliance, and OIG, Office of Inspector General, that maintains a listing of individuals and organizations that are sanctioned from participating in federal programs such as CMS. This listing is often referred to as the exclusion list, and PHD reviews this list every month to ensure our staff and vendors are not sanctioned from participating in federal programs. If they are sanctioned, the Public Health Department would potentially be committing fraud by requesting payment claims for their services. Fines can be steep and are based upon each request, so Public Health Department must be vigilant. The Public Health Department's compliance program consists of the ongoing monitoring of operations to detect and prevent non-compliance. This includes compliance with federal and state healthcare program requirements, specific grant requirements, county and public health department policy requirements, as well as overseeing ethical and moral issues, and prevents fraud, waste, and abuse across the department in all programs. Many recent activities have been associated with potential privacy security breaches and viruses caused by staff responding to phishing scams, that is, opening or clicking on links in fraudulent emails, or errors caused by staff assigning a patient guarantor, the person responsible for the patient's account with the Public Health Department, to the wrong patient. In the latter incidents, this mix-up in patient assignments caused patient billing to be sent to the wrong patient and thereby causing a breach of their protected health information. Public Health Department also has a responsibility to report breaches that they are aware of that they did not cause, as occasionally we receive hospital treatment information on patients that are not assigned to the Public Health Department and need to report this error back to the hospital so they can follow up their privacy breach protocols. So why do we need a compliance program? A, it helps us achieve our mission. B, it reduces our liabilities. C, it's part of many of our grant program requirements. D, it improves the quality of our services. E, A, C, and D above, or F, all of the above. The answer is F, all of the above. By practicing compliance, we ensure we are true to our mission and values, provide high-quality services in a fair and ethical manner, and meet or exceed our federal and state regulations, which protect our reputation and that of the county, and prevents us from receiving penalties or suspensions of funding for non-compliance. So who are some of the Public Health Department's compliance partners? A, county staff. B, vendors, or B, contractors. C, vendors. D, health center board members. E, all of the above. F, answer A, B, and D. The answer is again E, all of the above. To have a successful compliance program, all of our partners must know and be committed to compliance. State and federal regulatory staff provide information and interpretations of legislation and regulations that we can implement in our operations. Contractors and vendors perform services for our clients. Our health center board is comprised of community members and patients of the healthcare centers and provides guidance and oversight for our activities. This slide depicts the current organization of the compliance program. Because of financial, human resources, and contracting responsibilities, the Board of Supervisors has the ultimate authority in any county compliance program. The Health Center Board has an active role in compliance as it has authority delegated from the Board of Supervisors to review compliance issues and provide guidance and input into our health center operations. The compliance officer has the key role in working with county council and risk management to ensure the public health department is in compliance with a myriad of federal, state, and local laws and regulations, and to keep the public health department cabinet and the two boards informed of any compliance issues or risks. The compliance committee is composed of key representatives of executives, managers, supervisors, and staff members that represent each division and help to work with and oversee subcommittees that focus on elements of the compliance plan. So who is responsible for the Public Health Department compliance program? As this slide describes, compliance is everyone's responsibility within the Public Health Department. We all need to understand our role and actively participate in the program. No more excuses why I didn't know compliance was my responsibility, or I didn't know who to talk to if I have questions about compliance. The ultimate responsibility for compliance rests with the compliance officer, who acts at the direction and authority delegated from the Public Health Department Director, the Public Health Center Board, and ultimately from the County Board of Supervisors. Instances of fraud or the use of a staff member or vendor that has been sanctioned from participating in a federal healthcare program when seeking reimbursement for healthcare services from federal healthcare programs carries significant fines. For submitting false claims, up to $10,957 to $21,916 per claim, and potential exclusion from further ability to participate in Centers for Medicare, Medicaid Services programs. For use of an excluded vendor, up to $10,000 per event and up to treble the claim amount. In extreme cases, such as knowing that an individual or entity is excluded, but billing CMS for services provided by that individual or entity is fraud and subject to criminal prosecution. As mentioned earlier, non-compliance may trigger county discipline. Discipline for privacy and security policy violations in the last few years have ranged from consultation and retraining to suspension and terminations. In one instance where it was demonstrated the violation was intentional, a report was made to the state licensing board against the individual's license. Which organization or organizations recently reported security breaches? Security breaches are examples of non-compliance. Was it the Sacramento Bee, Panera Bread, MyHeritage, Facebook? Answers A and D only, or F, all of the above? The correct answer is, unfortunately, F. The Sacramento Bee newspaper had 19.5 million subscriber accounts breached. Panera Bread had 37 million accounts breached. Facebook had 87 million accounts breached, but MyHeritage genealogy determination services had 90 million user accounts breached. Facebook users' data was collected and analyzed as part of the 2016 presidential campaign without the approval of many of its members. The HIPAA Journal of 2019 provided information on healthcare record breaches that were reported. In 2015, there were more than 120 million healthcare records breached. That is more than 37% of the total population of the U.S. at the time. There still were almost 20 million records breached last year, 2018. The Public Health Department had several near misses in the last year, but has not had any reportable breaches. With the implementation of a new electronic medical record in February, we had several patients receive the billing information for another patient because the patient guarantor Person responsible on the account was incorrectly assigned by health center staff. With retraining, new workflows, and attention, we have greatly reduced these errors. One of our providers that had their login credentials captured through a phishing email. This led to access through Outlook web access to the provider's emails, which contained 50 partial patient records. Luckily, there was not enough information in these records for identity theft, but Public Health Department had to report this breach. True or false? In relation to compliance and ethics, conflict of interest refers to a work situation when a decision you are thinking about or have made not only impacts Santa Barbara County, but also impacts you personally. The answer is true. The cartoon image depicts a situation where an individual is in a position to select himself for a company award, in this case, Employee of the Month. The cartoon also seems to indicate that this situation has occurred several times. The other image depicts how valuing our own self-interest too highly can create an imbalance, a conflict, that may lead us to forsake our personal and county values, such as integrity, justice, equality, and others. Conflict of interest policies are included in the Public Health Department Compliance Plan and the County Purchasing Manual, which covers all the county policies for procurement, also known as contracts. County staff in a position to make decisions on contract awards or collecting fees from clients are required to prepare and submit an assessment of any personal conflicts they may have with these actions. Positions such as program managers, often contract monitors, managers, cashiers, etc. complete these conflict of interest statements, Form 700 under the Fair Political Practices Commission, and submit them to the county for review each year. Conflict of interest is also an issue with elected officials, and on occasion, such officials must exclude themselves from voting on an item for which they may have a conflict of interest. If at any time you feel you have a conflict of interest with an action or carrying out the responsibilities of your job, discuss it with your supervisor before proceeding. The Federal and California False Claims Acts have been in effect for many years and are designed to prevent fraud, waste, and abuse by empowering individuals to be able to report these issues to their administration without the fear of reprisals or discrimination. Reprisals are also known as retaliation, and these acts, as well as other laws and regulations, prevent the county or others from firing, demoting, or other means of harassing individuals for reporting or even alleging fraud. One of the most recent high-profile cases of retaliation involves Wells Fargo Banking Institute. In this situation, an employee reported to the government that Wells Fargo had committed fraud by creating bank accounts for many of its customers without their knowledge or approval. The employee was fired, but recently won a lawsuit against Wells Fargo for $5.4 million, and as part of the settlement was required to be rehired by Wells Fargo. Wells Fargo also settled the case with the government, including a $480 million fine. If this wasn't bad enough, Wells Fargo also was indicted in another case for mortgage and auto loan abuses that required many customers to purchase additional auto insurance and pay improper mortgage fees. The settlement for these activities was $1 billion. According to the False Claims Act, what is reckless disregard for the truth? A. Knowingly submitting a fraudulent claim. B. Keeping accurate records. C. Reviewing claims for mistakes prior to submission. D. All of the above. The correct answer is A. Reckless disregard for the truth is like an ostrich sticking its head in the sand. We all know it's wrong, but we do it anyway and commit fraud. True or false? Under the False Claims Act, an individual must knowingly act in a fraudulent manner to violate the act. The answer is false. Submitting a false claim, whether you knew it was a false claim or not, is a fraudulent act. If you discover a fraudulent claim and take appropriate and immediate steps to correct the problem, penalties can be waived. However, there are strict timeframes and reporting requirements that must be adhered to when correcting fraudulent claims, so the timing for reporting these problems is critical. Finally, if you knowingly submit false claims or find out after submitting a false claim and do nothing to report or correct the issue, penalties can be much stiffer and may include prison sentences, as you are essentially actively disregarding the law. What happens when the compliance officer receives a report of compliance issue? The compliance officer takes the lead to gather information on the report and to determine its validity. If the investigation determines that the issue raised is valid, the compliance officer is required to take appropriate action to correct the compliance issue. As with compliance issues described earlier, most of these corrective actions will be to revise policies and workflows to reestablish compliance. In some instances, these issues must be reported to federal or state health care programs. In extreme instances, the Public Health Department, Human Resources, and County Council become involved for staff disciplinary measures. In all situations, the compliance officer is required to track these investigations and to report these investigation outcomes on a regular basis to the Public Health Department Director, the Public Health Department Cabinet, and the Health Center Board. These records must be available for inspection during regulatory audits. So what are the potential penalties for non-compliance? A, criminal charges and possibly jail time. B, disciplinary action. C, $5,000 to $10,000 per event and up to 3 times the value of the claim. D, all of the above. The answer is D, all of the above. OCR, or the Office of Civil Rights, enforces the requirements in HIPAA. This headline is from a press release from the OCR that indicates 2018 was a record year for HIPAA enforcement activity and had fines of more than $28.7 million. Of this amount, the Cottage Hospital HIPAA breach from several years ago was settled in 2018, and Cottage Hospital was fined $3 million. This did not include all of the costs associated with notifying tens of thousands of patients, providing at least 1 year of credit monitoring for these patients, and the impact to their trust and goodwill in the community. In 2015, the U.S. Attorney General issued a memo known as the Yates Memo, as Sally Yates was the Attorney General at the time. This memo put healthcare executive suite staff members on notice that failure to address HIPAA issues and reported breaches could lead to criminal charges. As a result of this memo, several hospital administrators and healthcare plans have served jail time for HIPAA violations. Okay, we've given you some examples. You have questions or think you have discovered a compliance issue. How do you report this? The best way to do this is to report it through your supervisor. However, if you don't feel comfortable reporting to your supervisor or you want to report it anonymously, you have other options. You can use the compliance hotline, which is toll-free at 844-351-0659, the compliance fax line, or the compliance email. However, keep in mind that if you wish to report anonymously through the fax or email, you may have to use a machine or email account that cannot be traced back to you. This is not because we are trying to find out who is reporting something anonymously. It is just that the fax and or email contains information of the source, for example, the fax number sent from, email address of the sender, etc. In addition, staff members may file or participate in a lawsuit against an entity such as the county that commits fraud in relation to third-party payers like Medicare and Medi-Cal, and may receive a portion of any financial settlement as an outcome of the lawsuit. In Latin, the term quitam, which means to bring a lawsuit on behalf of another. In this case, the whistleblower is bringing the suit on behalf of the government. This option, under the Federal False Claims Act, protects whistleblowers from retaliation and is consistent with the Public Health Department's anti-discrimination policy in the compliance plan. This concludes our formal presentation. What if I think I have questions later? The best place for more information on the compliance program is the Public Health Department Compliance Program SharePoint site, which is hyperlinked for you on this slide. There you will find the compliance plan, information on the compliance committee, and frequently asked questions and answers. And the Public Health Department website has a compliance program web page that contains the same information for our compliance partners, as well as the online reporting tool. Also, the Public Health Department Compliance Hotline can be utilized to report compliance issues confidentially or anonymously. As mentioned earlier in the presentation regarding regulatory oversight of the healthcare industry, this slide provides the regulatory agency acronyms and some of the areas where their oversight impacts the Public Health Department operations.